Sex trafficking, warning signs, the new or should have known standard. Attorney Andrew M. Stengel. The federal TVPRA's civil liability provision does not require proof of actual specific knowledge of sex trafficking. Instead, the law holds businesses liable if they knew or in reckless disregard of the fact should have known that trafficking was occurring. Alongside the TVPRA, New York Social Services Law, Section 483-BB gives survivors an additional civil cause of action under state law. Together, these two statutes fundamentally changed civil sex trafficking litigation. What should have known means in practice in New York. The should have known standard asks a direct question. Would a reasonable business with the same available information have recognized that sex trafficking was occurring? Courts examine several key factors to answer that question. They consider whether sex trafficking warning signs were obvious. They also ask whether the business received complaints or reports about suspicious activity. Additionally, courts evaluate whether the business maintained policies designed to detect trafficking. Both the TVPRA and Section 483-BB apply the same rule. Ignorance is not a defense when warning signs were present and ignored. Sex trafficking warning signs. New York businesses should recognize. Sex trafficking warning signs vary by industry, but several red flags apply broadly. Guests or customers who pay exclusively in cash raise immediate concern. Similarly, individuals who appear disoriented, malnourished, or fearful of those around them deserve close attention. A person who lets someone else speak for them, especially in private settings, may not be acting freely. Additionally, high foot traffic in and out of a single room signals a serious problem. Multiple visitors at unusual hours and requests for excessive linens also raise red flags. Under Section 483-BB, businesses that fail to act on these warning signs can face direct civil liability in New York courts. Industry-specific awareness in New York. Different industries carry different levels of awareness about sex trafficking risks. The hotel industry, for example, has faced extensive public awareness campaigns, government publications, and industry training programs. These resources specifically address sex trafficking warning signs on hotel properties. A hotel chain claiming ignorance of trafficking in its rooms faces a serious credibility problem. Industry-wide awareness makes that claim very difficult to sustain in court. Moreover, other industries, including truck stops, massage businesses, and online platforms, also face growing scrutiny. Section 483-BB reinforces this accountability by extending civil liability to anyone who knowingly benefits from a trafficking venture in New York. Sex trafficking, corporate policy, and training failures. In litigation against corporate defendants, attorneys dig into training materials, corporate policies, and internal communications. Companies that created anti-trafficking policies but never enforced them face especially strong arguments against their defense. Similarly, companies that offered inadequate or undelivered training programs struggle to credibly claim a lack of knowledge. The gap between written policy and actual practice often proves decisive. Furthermore, under Section 483-BB, a company's failure to implement its own policies can support a finding that it knowingly benefited from trafficking. Internal emails, employee complaints, and prior incidents can all become powerful evidence against a corporate defendant. Why civil litigation matters for survivors of sex trafficking. Skilled sex trafficking attorneys use the new or should have known standard to build a strong factual record through discovery. They document the defendant's direct exposure to sex trafficking warning signs. They also identify the defendant's failure to act on information it already had. Furthermore, they highlight the gap between industry best practices and the defendant's actual conduct. Experienced attorneys pursue claims under both the TVPRA and Section 483-BB, simultaneously maximizing the legal pressure on corporate defendants and expanding the potential for recovery. Contact the law firm of Andrew M. Stengel. Businesses cannot simply claim ignorance when sex trafficking occurs on their premises. Survivors deserve justice, and the law provides a clear path to hold these companies accountable. Contact the law firm of Andrew M. Stengel, PC today to learn whether the businesses that enabled your trafficking can face civil liability. We offer free confidential consultations and charge no fee unless we win your case. Email us at info@stengellaw.com. For more information, please visit our website, stengellaw.com. Attorney advertising. Prior results do not guarantee a similar outcome.